Hey VCEers! Let's talk about dispute resolution methods used by courts and VCAT. You need to memorise the four following processes: mediation, conciliation, arbitration, and judicial termination. You need to know what they all are and what sets each one apart from the other. Questions on this area come up relatively often in exams. There were questions on dispute resolution methods in the 2012 and 2013 exams, and there were 2 questions in 2014. These questions can be broad or specific. In 2013, for example, students were asked, for 4 marks, to describe 2 dispute resolution methods that are used by courts, whereas students were asked in the 2014 exam, very specifically, to describe one difference between conciliation and arbitration as dispute resolution methods, and later on, to explain the dispute resolution method that will be used by the Supreme Court of Australia Trial Division. Those last 2 questions were worth 3 marks each. To describe a dispute resolution method, you need to name the third party, outline their role, state how formal the method is, and note whether the decision is legally binding. If you're describing a difference between 2 methods, look at those 4 points and find the point at which the methods deviate. Now, let's go through each method. Firstly, we have mediation. The name of the third party is the mediator, and the mediator's role is to guide the parties to a resolution without making any actual suggestions. It's a very informal process. There are no wigs or robes, and the mediator sits on the same level as the parties. The decision made at the end of mediation is not legally binding. However, parties often afterwards sign a legally binding contract based on the agreement they came to. Secondly, there's conciliation. This is another informal process, and like in mediation, the decision made is technically not legally binding, although parties will often sign a legally binding contract based on their agreement. However, the name of the third party is the conciliator, and the conciliator's role differs from the mediator's. Conciliators also guide parties towards a resolution, but they are allowed to suggest possible resolutions. Third, we have arbitration. The third party, the arbitrator, will seek a mutually acceptable resolution, but if the parties can't agree, the arbitrator will make a decision. This process is less formal than judicial determination, but more formal than mediation and conciliation, since the arbitrator sits on a seat that is physically higher than the parties. The decision that the arbitrator makes is legally binding. Fourth, there's judicial determination. This is the most formal of all 4 methods. A third party, the judge, will hand down a legally binding decision in favour of one of the parties. So there you go. Those are the 4 methods and the 4 characteristics that distinguish them from each other. I know it's a lot of content, but you really need to memorise all of that information. Thanks for watching and happy studying.